My biological mother demands I give her half my inheritance because she's my real parent after she gave me up for adoption at birth. The letter arrived on a Wednesday morning, slipped between a utility bill and a coupon circular, like it was nothing, like it was ordinary mail from an ordinary world. I almost didn't open it. The return address was a law firm in Tucson I'd never heard of, a place called Delacroix and Ambrose, and the envelope was thick cream-colored paper that felt expensive in a way that made my stomach tighten before I'd even broken the seal. I stood at my kitchen counter in Portland, still in the clothes I'd slept in, holding a mug of coffee that was going cold, and I read the first paragraph 3 times because my brain kept refusing to process what it said. The letter was from a woman named Renata Voss. It stated, "Are in the dry and precise language of legal correspondence that Renata Voss was my biological mother, that she had recently learned of the death of my adoptive father, Gordon Ellsworth, and that she was formally asserting a claim to 50% of my inheritance on the grounds that she was, and I am quoting directly here, my natural and original parent whose biological contribution to the plaintiff's existence constitutes a foundational claim upon any estate to which the plaintiff is beneficiary." I put the mug down. I put it down very carefully because my hand had started shaking, and I didn't want coffee on the letter. I needed the letter exactly as it was. I needed every word of it to remain intact because I was going to need a lawyer, and I was going to need every word. I had known I was adopted since I was 5 years old. My parents, Gordon and Maureen Ellsworth, told me the way good parents tell children things. Simply, clearly, and with enough warmth that the information never felt like a wound. They sat me down in the living room of our house in Eugene, Oregon, on a Sunday afternoon with the late autumn light coming through the windows, and my father said, "We chose you." That was how he put it. Not that my biological mother had given me up. Not that I'd been surrendered or abandoned or any of the other words that carry weight. He said they had chosen me, specifically, from among the children at the adoption agency, because when they held me, something settled into place. My mother cried a little when he said that. I didn't understand why at the time, but I was 5 and more interested in whether I could have a cookie after, so I filed it away and moved on. I grew up knowing the fact of my adoption the same way I knew the fact of my blood type or the fact that I was left-handed. It was simply true, simply part of the architecture of who I was, and it caused me no distress. Gordon and Maureen Ellsworth were my parents in every sense that mattered. Full stop. No asterisk, no footnote. My father, Gordon, was a civil engineer who designed bridges for the state of Oregon for 31 years and who spent his weekends building furniture in the garage and listening to jazz at a volume that drove my mother gently insane. He was a quiet, methodical man who expressed love through acts of precise, unhurried attention, who remembered every small thing you'd ever mentioned wanting and who showed up with it 6 months later like it was nothing. He taught me to drive in an empty parking lot on a Sunday morning when I was 15, patient through every stalled engine and lurched stop, never once raising his voice. He came to every cross-country meet I ran in high school, stood at the finish line in all weather, and handed me a water bottle without making a production of it. He paid for my architecture degree at the University of Oregon and then helped me move to Portland when I got my first job at a mid-sized firm, carrying boxes up 3 flights of stairs without complaint, and refusing to let me take him to dinner afterward because he said the traffic coming back would be terrible. He was the most genuinely decent person I have ever known, and he died of a cardiac event at 71 in March of this year in his own bed with my mother holding his hand. He left me the house in Eugene, a savings account containing $218,000, his tools, his jazz records, and the half-finished oak bookcase that was still in the garage. He left me a whole life worth of love, carefully saved. And now, a woman I had never met was claiming half of it. I called my mother in Eugene before I called anyone else. She answered on the second ring, the way she always did, and I read her the letter, word by word, standing in my kitchen, watching the rain streak down the window. She was quiet for a long time when I finished, and then she said, "I was afraid of this." I asked her what she meant. She said that when they had adopted me, the agency had arranged an open adoption, meaning my biological mother had the right to receive annual updates on my well-being until I turned 18, which Gordon and Maureen had honored without exception, sending photographs and brief letters every year to an address they were given. They had never met Renata Voss. They had never spoken to her directly, but they had known her name, and Gordon, in the months before he died, had mentioned to my mother that he was concerned. He'd said, "If something happens to me, Maureen, I want you to know that woman is out there." He didn't elaborate further. He was not a man who elaborated on fears, but he had said it, and my mother had filed it away. And now here we were. I told her I was going to find a lawyer that afternoon. She said, "Use someone good, not just cheap." She said it, the way my father would have said it, practically and without drama. And I felt the familiar specific grief of missing him land on me again, like something physical. I found my lawyer through a colleague at the architecture firm, a woman named Priya, who had gone through a complicated estate dispute with her own family 2 years earlier, and who gave me the name of her attorney without hesitation. His name was Douglas Farrell, and he had been practicing estate and probate law in Portland for 19 years, the last 8 as a partner at a firm called Farrell and Okonkwo. He had thick silver hair, reading glasses on a chain around his neck, and a manner of speaking that was unhurried and precise in a way that immediately reminded me of my father, which I chose to take as a sign. I sat across from him in his office the afternoon I received the letter and handed it over. He read it in silence, his expression giving nothing away, and then set it on his desk and looked at me. He said the claim had no legal merit whatsoever. He said that adoption terminates all legal rights and responsibilities between a biological parent and a child, comprehensively and permanently, and that Renata Voss had surrendered any legal claim to me or anything connected to me the moment the adoption was finalized 32 years ago. He said the letter from Delacroix and Ambrose was, in his professional opinion, either a desperate bluff or the product of an attorney who was incompetent or who had been misled by their client about the facts of the situation. He said he would draft a formal response that afternoon and that I should not contact Renata Voss directly under any circumstances. He paused and looked at me over his glasses. Then he asked, "Have you ever had any contact with her?" I said no. He nodded and wrote something down. As he said, "Keep it that way for now." I kept it that way for exactly 11 days. On the 12th day, she called my cell phone. I don't know how she got the number. I stared at the unfamiliar Arizona area code for 3 full rings, telling myself it could be anything. A wrong number, a spam call, someone from a project I'd worked on years ago. Then I answered, because I am the kind of person who answers, which is both a virtue and a consistent source of problems. The voice on the other end was a woman's, mid-50s by the sound of it, with a slight roughness to it like someone who had spent years either smoking or shouting or both. She said, "Is this Nolan?" My name is Nolan Ellsworth, the name my parents gave me, the only name I have ever had or wanted. I said yes, and she said, "This is Renata." And then she said, "I'm your mother." And the words sat in the air between us like something that had been dropped from a great height. I thought of Gordon Ellsworth carrying boxes up 3 flights of stairs. I thought of Maureen holding his hand at the end. I said, "I have a mother." She said she understood that, but she was my biological mother, and that counted for something. I told her my attorney had sent a response to her legal claim, and she should be speaking to Douglas Farrell rather than to me. She said she wasn't calling about the legal claim. She was calling because she wanted to talk, person to person, before things got complicated. I said things were already complicated. She said she knew that, and she was sorry, and could we just talk for a few minutes, just talk. And despite every reasonable instinct I possessed, I stayed on the line. Not because I trusted her, yet because I needed to understand what I was dealing with. She talked for 23 minutes. I timed it, keeping one eye on the clock on my microwave, making notes on the back of an envelope with a pen I grabbed from the counter. She told me she had been 19 when she got pregnant, that she had been in a bad situation, that she had made the hardest decision of her life by placing me for adoption, that she had thought about me every single day for 32 years. She said she had eventually married, had 2 other children, had built a stable life in Tucson, but that she had always kept track of me through the annual updates, had watched me grow up in photographs, had felt connected to me in a way she couldn't explain. She said when she heard Gordon had died, she had felt grief too, on grief for a man she'd never met but who had raised her son, and she said the word son like it cost her something to say it. Then she said, "I'm not doing well financially." She said it without preamble, without softening it, which I'll give her credit for. She said her husband had left 3 years ago, that the divorce had been expensive, that she had medical bills. She said she wasn't asking for everything, just half, just enough to stabilize things. She said she had given me life, and that counted for something, that biology was real, that she had carried me for 9 months, and that should matter in some accounting of the universe. I asked her one question when she finally stopped. I asked, "Did you know my father?" She meant Gordon. I said, "Yes." She went quiet for a moment. Then she said, "I heard he was a good man." I said, "He was the best man I've ever known." And I ended the call. I called Douglas Farrell the next morning and told him about the phone call. He was quiet for a moment and then asked if I had recorded it. I said no. He said that going forward, if she contacted me again, I should record every conversation, that in Oregon, single-party consent meant I could legally record any call I was part of without notifying the other party. He said the phone call itself was mildly concerning because it suggested Renata Voss was not simply following her attorney's strategy, but was acting impulsively, and impulsive people in legal disputes do things that are useful to the opposing party. He had already filed a formal response to Delacroix and Ambrose on my behalf, citing the finalized adoption decree, the complete and permanent termination of parental rights, and the absence of any legal mechanism by which a biological parent who voluntarily surrendered a child could later claim an interest in that child's inherited estate. He said he expected the other attorney to either withdraw the claim entirely or fail to respond within the statutory period, at which point the matter would be closed. I asked him what the worst-case scenario was. He said, if they actually filed suit, we would win, but it would take 6 to 18 months and cost you between $15,000 and $40,000 in legal fees, which you would be unlikely to recover. He said it without softening. That was the worst case. Not losing, just bleeding. She called again 4 days later, at 7:42 in the morning, before I'd had coffee. I had downloaded a call recording app the day after speaking to Douglas, and I tapped record before I answered. This time, her tone was different. The first call had been almost gentle, careful, the voice of someone building something. This one was harder, like she'd spent the days between working herself up. She said she didn't understand why I was making this so difficult. She said she had rights. She said she was my mother, my real mother, and the people who adopted me had just been caretakers. I felt something go cold in my chest when she said that. Just caretakers. 32 years of love and presence and choosing me, distilled by a stranger into the word caretakers. I kept my voice level. I said Gordon and Maureen Ellsworth were my parents and the only people I had ever considered my parents. And that the adoption had been legal and permanent and had ended any claim she might have had to any part of my life before I could walk. She said she didn't care about the legal technicalities, that family was more than paperwork. I said, you signed the paperwork. She said she had been a teenager in a desperate situation. I said, that's a reason, not a reversal. She raised her voice and said she had given me life and I owed her. I told her this conversation was being recorded and ended the call. My hands were steady when I put the phone down. I was surprised by that. I felt nothing in the way you feel nothing when something has moved past surprise into something colder and more structural. Douglas reviewed the recording the same day and said it was useful documentation of her stated belief that I owed her, which would be relevant if the matter went to litigation. He also mentioned something that surprised me. He had done some preliminary research on Renata Voss and had found a public record of a civil judgment against her in Arizona from 4 years earlier, a creditor claim for $31,000 from a personal loan default. He said he was not surprised. He said people who pursue legally baseless inheritance claims against adopted children are rarely doing so from a position of philosophical conviction. They are doing so from a position of financial desperation, and financial desperation makes people do things that create records. He was building a picture methodically, the way my father would have approached an engineering problem, and I was grateful for it. He told me to continue documenting everything and to tell my mother and Eugene to do the same if Renata attempted to contact her. I called Maureen that evening and told her. She said she'd write down any contact attempts in a notebook with dates and times. She said it in the steady way she did most things, but I could hear something underneath it. A weariness that I didn't want to put more weight on than necessary. She had just lost her husband. She was 69 years old, and she was being asked to document attempts by a stranger to take half of what he'd left behind. The wrongness of it sat in my stomach like something I couldn't digest. 3 weeks after the first letter arrived, a second piece of correspondence came from Delacroix and Ambrose. This one was longer, more detailed, and considerably more aggressive. It cited a legal theory I had not heard of before, something the letter called equitable parentage, and argued that Renata Voss's biological relationship to me, combined with her consistent interest in my well-being as evidenced by the annual updates she had received, constituted a form of parental connection that should be recognized by a court of equity when distributing an estate. Douglas read it and used a word I had not previously heard him use. He said, absurd. He said the equitable parentage doctrine existed in some states in very limited forms related to child custody situations involving non-biological parents who had functioned as primary caregivers, and that applying it inversely to a biological parent who had surrendered a child and received annual updates was so far outside established case law as to be essentially fictional. He said the attorney at Delacroix and Ambrose, a man named Philip Ambrose based on the signature, was either creatively desperate or had found a sympathetic reading of a fringe legal theory and was hoping I would settle rather than fight. He said his response would be thorough and would include a formal motion for attorney's fees if the matter proceeded to filing, which creates a financial risk for the opposing attorney that often resolves situations quickly. I asked if he thought it would resolve it. He said, I think she needs money more than she needs justice. and that usually resolves itself eventually, one way or another. It was my therapist who helped me understand what was actually happening to me emotionally, because Douglas was handling the legal reality and doing it well. But there was a different thing going on underneath the legal reality that I wasn't managing as cleanly. Her name was Dr. Simone Okafor, and she had a practice in Northeast Portland focused on adoption-related psychological issues, which felt almost too specifically relevant to be coincidental, but which my primary care physician had recommended after I called and explained what was happening. She was a composed woman in her mid-40s with close-cropped natural hair and an office full of plants that she tended with what seemed like genuine affection. I'd been seeing her for 2 weeks when I told her about the cold feeling I described to Douglas, the one that replaced surprise. She said, "Tell me more about that." I said it felt like something had been decided, like a door had been closed. But I wasn't sure if I had closed it or if it had always been closed and I was only now noticing. She nodded and asked me what I thought I had been hoping for before Renata called. I said I hadn't been hoping for anything because I hadn't been thinking about her. Dr. Okafor said, "That's worth sitting with. The absence of hope can look like peace from the outside and feel like suppression from the inside." I thought about that for a long time after the session. On a Thursday morning, 6 weeks after the original letter, I got a call from a woman named Irene Nakashima. She introduced herself as a journalist with a regional news site that covered Pacific Northwest legal and social issues, and she said she was working on a story about adult adoptees and inheritance disputes, and that she had heard about my situation through a source she declined to name. My stomach dropped. The last thing I wanted was public attention on any of this. I told her I couldn't comment on an ongoing legal matter, which was accurate and also the thing Douglas had told me to say if media ever contacted me. She was polite and said she understood, but asked if I would be willing to speak generally about the experience of being an adoptee facing a biological parent's legal claim. I said I needed to think about it and took her number. I called Douglas immediately after hanging up, and he said, "Don't talk to her yet." He said the story running without my perspective would be worse than the story running with it, but that the timing mattered and I should wait until we had a clearer sense of how the legal matter was resolving. He said he'd had a development he wanted to discuss in person, and we arranged to meet the following morning. The development was significant. Douglas had obtained, through a records request related to the legal proceedings, a document that Renata's attorney had submitted as part of their equitable parentage argument, a collection of the annual update letters and photographs that Gordon and Maureen had sent over the years, which Renata had apparently kept in a binder and provided to Philip Ambrose as evidence of her ongoing connection to my life. Douglas laid them out on his desk, 32 photographs, one per year, from infancy to age 18. Me in a hospital receiving blanket, 2 days old. Me at 5 in the backyard in Eugene with a gap-toothed smile. Me at 12 at a cross-country meet, mid-stride. And my father visible at the edge of the frame. Me at 17 at graduation, my mother beside me, both of us squinting into the sun. I looked at them for a long time. Douglas said, "The irony is that these documents she's using as evidence of her connection to you are actually evidence that the Ellsworths honored every obligation of the open adoption in full, and that her entire knowledge of your existence came from their generosity in sending these updates, not from any action of her own." I picked up the photograph from when I was 12. My father was wearing a green fleece jacket, I remembered. He was standing at the edge of the frame because he always stood at the edges, giving the subject room. The grief landed on me again, hard and specific, and I set the photograph down and told Douglas I needed a minute. And as he said, of course, and left the room, and I sat alone in his conference room for about 4 minutes, long enough to get the feeling back under control before he came back in and we got to work. Philip Ambrose filed the actual lawsuit on a Monday morning 8 weeks after the original letter. Douglas called me before I'd seen the filing, with the tone of someone who has bad news that is also, in a certain light, useful news. He said, "They filed." He said it means Ambrose either genuinely believes in the theory, or Renata pushed him into it over his better judgment. He said it triggered a court process that would eventually produce a ruling, and that the ruling would be in our favor, but that the timeline was now 6 to 12 months minimum. I said, okay. He asked if I was all right. I said I was more angry than scared, which he said was a reasonable way to feel and also strategically useful. He said he was filing an immediate motion to dismiss on the grounds that the legal claim had no basis in Oregon or Arizona law, and simultaneously filing the motion for attorney's fees, which would put Philip Ambrose personally at financial risk if the case proceeded and failed. He said he expected the motion to dismiss to be heard within 60 days before Judge Annette Burrow, who had 26 years on the Multnomah County bench and a reputation for having limited patience with creative legal theories unsupported by precedent. He said, "I have appeared before Judge Burrow 11 times. She is not going to like this case." The 60 days between the filing and the hearing were the strangest period of the whole ordeal. Although the legal machinery was running without needing much from me, Douglas was handling everything, Dr. Okafor was helping me process the emotional dimensions of it, and there was nothing left for me to do except wait and work and occasionally stare at my phone when it rang with an unknown number. Renata called twice more during those 2 months. Both times I recorded the calls. The first was at 9:15 in the evening, and she was crying, or performing crying. I genuinely couldn't tell which, telling me she didn't understand why I was fighting her so hard, that she had never wanted to hurt me, that the lawsuit was just a formality, and she thought we could still have a relationship. I asked her, as calmly as I could manage, why she thought demanding half my inheritance was a reasonable starting point for a relationship. She said she needed me to understand what it had cost her to give me up. I said, I understand it cost you something. It cost my parents nothing, because they never thought of me as a cost. She was quiet for a moment, and then she said something that I have thought about many times since. She said, "You hate me?" I said, "I don't know you." Those are different things. She said they felt the same. I ended the call. The second call came on a Wednesday at 11:30 in the morning while I was in a client meeting. I stepped out to take it because the Arizona area code had taken on a Pavlovian quality, and I couldn't ignore it. She wasn't crying this time. She sounded businesslike, almost rehearsed. She said Philip Ambrose had told her the case was not going well and that she wanted to propose a settlement. She said she was willing to drop the claim entirely in exchange for a one-time payment of $25,000, which she framed as a voluntary acknowledgement of her role in my life. I said I would relay the offer to my attorney, which was true, and ended the call. I texted Douglas from the hallway before I went back into the meeting. He called me an hour later and said, "Don't take it." He said a $25,000 settlement would be characterized as validation of her claim and could create grounds for future demands. He said Judge Burrow was hearing our motion to dismiss in 3 weeks, and he was confident in the outcome. He said if Renata wanted to drop the case voluntarily before the hearing, she was welcome to do so with zero payment from my side. Otherwise, we would proceed. I authorized him to relay that position to Ambrose, which he did within the hour. Ambrose responded by email the following morning with 2 words: "We'll proceed." The hearing before Judge Burrow lasted 45 minutes. I sat in the gallery and watched Douglas Farrell do 19 years of estate and probate law in a courtroom the way a surgeon does surgery, efficiently, without wasted motion, without emotional performance. He presented the finalized adoption decree. He presented Oregon and Arizona adoption law, citing specific statutes. He presented the absence of any precedent for the equitable parentage theory being applied in the way Ambrose was applying it. He presented the original surrender documents Renata had signed in 1993, which terminated her parental rights comprehensively and permanently. He presented the judgment lien against Renata from 4 years earlier. Thus, he presented both recorded phone calls in which she explicitly stated I owed her, framing the lawsuit not as a legal claim, but as an attempt to collect what she had decided she was entitled to. Philip Ambrose argued his equitable parentage theory with what I can only describe as the energy of a man who knows he is losing, but has committed to the direction. Judge Burrow interrupted him twice with questions he did not answer well. I watched her face while he spoke. She was a compact woman in her early 60s with silver-framed glasses and an expression of sustained professional skepticism. She did not look impressed. She did not look angry. She looked like someone listening to an argument she had already decided was insufficient. Judge Burrow granted the motion to dismiss from the bench. She did not reserve decision or take it under advisement. She ruled on the spot, in language that was measured and thorough and, in its quiet way, devastating to the case Renata had built. She said the equitable parentage doctrine, even in its most expansive forms, had never been applied to provide inheritance rights to a biological parent who voluntarily surrendered a child through legal adoption, and that applying it in that manner would fundamentally undermine the legal finality upon which adoption law depends. She said the adoption decree executed in 1993 was a complete and permanent termination of the plaintiff's legal relationship to the defendant, and no subsequent circumstances, including financial need or claimed emotional connection, altered that legal reality. She said the court found the claim to be without merit and that the motion to dismiss was granted with prejudice, meaning Renata could not refile the same claim. She then addressed the motion for attorney's fees, took it under advisement, and said she would issue a ruling within 30 days. She looked at Philip Ambrose over her glasses when she said that, and his jaw tightened in a way that suggested he already knew how it was going to go. I sat in the gallery and felt something leave my body that I hadn't fully known was there. Not the cold feeling from before, something heavier, the specific weight of a thing that has been fought and finished. Douglas turned to find me in the gallery as the courtroom cleared and gave me a brief, satisfied nod. outside in the corridor, is he said the fee ruling would likely come in between $12,000 and $20,000, payable by Renata and potentially by Ambrose jointly, depending on how Judge Burrow assessed his conduct in pursuing the case. He said it was not certain, but it was likely, and that it would function as a meaningful financial consequence for both of them. He shook my hand and said, "You handled this well." I said he had handled it well. He said, "That's true, but you didn't make it harder," which is more than I can say for most clients. I laughed for the first time in 2 months. It was a small laugh, in a courthouse corridor, over a compliment from my lawyer, but it was real. I called my mother from the parking lot. She answered on the second ring. I told her it was over. She said, "Your father would have said that's what he expected." I said, "I know." We were both quiet for a moment, and in the quiet, I could hear the specific sound of the house in Eugene. The furnace clicking, the way the wind came off the hills in early spring, a sound I had known my whole life. She asked if I was coming home for the weekend. I said I would be there Friday afternoon. Judge Burrow issued the attorney's fees ruling 22 days after the hearing. She assessed $16,500 in fees against Renata Vos and Philip Ambrose jointly, with a note that Ambrose's decision to pursue a claim with no supportable legal foundation had contributed to unnecessary litigation costs and reflected poorly on his professional obligations. The note was not legally binding, but it was public record, which Douglas pointed out was its own form of consequence. Philip Ambrose's name was now attached to a judicial finding that he had pursued an unsupported claim and incurred a fees award as a result. That tends to follow an attorney in a way that is difficult to shake. I found myself feeling something unexpected about Renata Vos after the fee ruling. Not sympathy exactly, but something adjacent to it. A recognition that she was now facing $16,500 in legal fees on top of whatever she had paid Ambrose to bring the case in the first place. All of it on top of whatever financial crisis had driven her to contact me in the first place. She had tried to reach into my inheritance and had instead made her situation considerably worse. The law had worked the way it was supposed to work. I wasn't certain whether to feel satisfied by that or sad by it or simply neutral. I landed somewhere between all three. I called Irene Nakashima 3 weeks after the ruling. I had thought about it carefully, talked it through with both Douglas and Dr. Okafor, and decided that speaking on the record served a purpose that was larger than my own privacy. Dr. Okafor had said in one of our sessions, "Your story is not an unusual one. Adopted adults face this kind of claim more often than people realize. And the cultural mythology around biological parenthood makes it harder to defend against emotionally, even when it's legally clear." She said visibility matters for people who are going through the same thing without the resources to fight it. We spoke for 2 hours, Irene and I, in a coffee shop in Southeast Portland on a rainy afternoon. I told her everything I've told you in the same order, the same detail. I showed her the original letter. I showed her the adoption decree. I showed her the court ruling. She was a thorough and fair reporter. And when the piece published 2 weeks later, it was exactly what I had hoped it would be: careful, specific, and honest about what the law actually says and what the experience of being on the receiving end of this kind of claim actually costs. The comments were overwhelmingly from other adopted adults who had experienced similar pressure from biological relatives, some of them without the resources to hire a Douglas Farrell, some of them who had settled out of exhaustion or guilt. That last part stayed with me. I drove to Eugene on a Saturday morning in June, 4 months after the letter had arrived. I went because it was my mother's birthday and because I had been going to Eugene for my mother's birthday for 31 years, and some things you don't stop doing. I parked in the driveway of the house I had grown up in and sat for a moment looking at the front door. The garden was doing well. The roses my father had planted along the fence line the spring before he died were blooming in a way that seemed slightly improbable, deep red against the gray of the Oregon morning. My mother came to the door before I'd finished getting out of the car. She looked well, steadier than I'd expected, moving through her grief with the same practical quiet with which she moved through everything. We had lunch at the kitchen table and talked about normal things, about my work, about her book club, about the neighbor's new dog. After lunch, she took me out to the garage. The half-finished oak bookcase was still there, exactly where my father had left it, sitting on the workbench with his tools arranged around it with characteristic precision. She said she wasn't sure what to do with it. I said, "I'll finish it." She looked at me for a moment in the way she sometimes looked at me, taking some kind of inventory I didn't fully understand. Then she nodded. I went back to Portland that evening with his tools in the back of my car, wrapped carefully in the green shop cloth he'd always used, and the wood grain plans he'd drawn by hand in his neat engineer's lettering. I started working on the bookcase the following weekend in my apartment, spreading drop cloths across the floor and measuring twice before every cut. He had gotten the joinery about 2/3 finished, and the rest was mine to do. I worked slowly, the way he had taught me, and I did not rush. And when I finally got the proportions right, when the pieces came together the way they were supposed to, the satisfaction I felt was quiet and deep and entirely my own. I heard from Douglas one final time about Renata Voss, 8 months after the ruling. He called to let me know that the fee judgment had been recorded as a lien against her property in Tucson, meaning she couldn't sell or refinance anything without satisfying the debt. He said she had made no attempt to appeal and no attempt to contact me again, as far as he was aware. He said, "I think she understands the matter is closed." I thanked him and asked if there was anything else. He said no, and we said goodbye. And that was the last time I thought about Renata Voss for a long time. Doctor. Ms. Okafor and I had our last session in September of that year. She said I'd done the work, which was her way of saying therapy had accomplished what it needed to accomplish, and that the door was open if I needed to come back. I said I appreciated that. She asked at the end of the session how I wanted to remember the whole experience. I thought about it for a moment. I said, as proof that a thing can be legally closed and emotionally complicated at the same time, and that both of those states are okay? She smiled and said, "That's a good answer." I think about my father most days, and the thinking is clean now, without the complication of anger getting mixed into the grief. Gordon Ellsworth built things that lasted, bridges across rivers, a family from nothing but intention, a half-finished bookcase that is, as of last month, finished and standing in the corner of my apartment, the wood grain exactly the color of the wood grain in his drawings, the joints tight and true. He chose me at the beginning. I am carrying that forward. That is the only inheritance that matters.